Hi, I'm Phillip Cha. I'm a mediator and founder of Cha Mediation Services. I specialize in mediating employment and business disputes. For this segment, I want to talk about how the mediator selection process works. The first obstacle when it comes to mediations is getting an agreement to go to mediation in the first place. But once you've cleared that hurdle, the next step is to pick a mediator. So who gets to pick the mediator? Well, each side has to agree to use the mediator, so naturally each side should have input. When I was a practicing attorney, the typical practice was for the defense to defer to the plaintiff in terms of suggesting the first round of names of potential mediators. I think the thinking at that time was that the plaintiff and the plaintiff's attorney should be comfortable working with the mediator in order to be in the best mindset for settlement discussions. Now that said, if the defense isn't comfortable with any of the names proposed by the plaintiff, then it may be appropriate to propose some additional names for the plaintiff to consider. Either way, there is no one-size-fits-all when it comes to mediators. Mediators come in all shapes and sizes and styles and personalities, and what might be the right fit for one case may not be a good fit for another. Some mediators take an aggressive, in-your-face and what I would call a tough love approach. Others have a softer touch. Some mediators are retired judges, while others may be former attorneys who have subject matter expertise in a given practice area, much like myself. Mediators' gender or ethnic background also may be a factor that has influence or an impact on the parties in a positive or even a negative way. Accordingly, if your goal is to maximize your chances of success at a mediation, the parties really need to give careful thought and careful consideration to finding the right fit for the case, and not just rely on habit or taking the easy path. Next, who pays for the mediator? Do the parties split the cost 50-50? Does one side agree to pay the entire amount? Using the dreaded lawyer speak, which I'm trying to avoid now that I'm a recovering attorney, the answer is it depends, because it does depend on the situation. The thinking behind the 50-50 split is that it gives each side an equal investment in the mediation, or what's called skin in the game. Where the investment is unequal, like when one party agrees to pay the entire amount, the concern is that the non-paying side has less invested and therefore less of an incentive to negotiate and settle. Lastly, the parties can also structure their settlements so that one side agrees to reimburse the other side for its share of the mediation fees as part of or in addition to the settlement amount. Sometimes this type of incentive really can be the final push and get the parties over the hump in reaching a settlement after a long day of negotiations. Thank you for tuning in. If you like this video, please subscribe to my YouTube channel. You can also check out my website at www.chamediation.com. I'm also on social media. Links to my Facebook, Twitter, and LinkedIn accounts are in the description box below. And in the meantime, please stay tuned for more content. See you soon.